Kanu, who has been in detention since 2021, on Wednesday in a motion requested the court to restore the bail granted him in 2017 by the state trial judge. Kanu's lawyer, Aloy Ejimako, told the court that his client's motion was caution to Section 169 of the Administration of the Criminal Justice Act 2015. Ejimako also told the court that his client filed a separate agitation requesting his removal from the custody of the State Security Service to a house arrest or the alternative to be remanded in prison on grounds that the State Security Service facility where Kanu is being held is conducive in preparations for his trial. Kanu also asked that his lawyers be allowed unhindered access to him to enable him prepare his defense and the terrorism charges against him. The defendant also asked the court to set aside the arrest warrants issued against him by the court while he was out of the country. However, the federal government's legal team, Adegboyega Awomolo, SAN, opposed granting of all the requests made by Kanu. Amongst others, the senior lawyer said that in a criminal matter, no defendant has the right to detect to the court how his prosecution will be conducted about his request of removal from the State Security Service custody. Awomolo said the only safe and secured environment for Kanu is the State Security Service custody in the interest of safety of his life. After listening to both lawyers, the trial judge ordered that the trial commences after the prosecutor told the court that they were ready, but the defense says they were not. Justice Binta Ayako, however, threatened to adjourn indefinitely if the trial following the submission of Kanu's special counsel, saying they are not ready.
It is not about having access to our client. We do have access, but our access is monitored, hampered to the point that we are unable to discuss with him within that zone of confidentiality that is guaranteed between a lawyer and his client. So our position comports with the law, with Section 36 of the Constitution, that unless fair hearing can be guaranteed, no Nigerian can be subjected to any trial.
Now that I don't have any confidentiality with my client, how do you want me to enter to take him on trial? It is against the rules of professional ethics for a lawyer to commence a trial with a client that you never prepared for. So, and I told the judge our predicaments, the evidence are there, and the judge insisted on going on a trial. Trial for what?
At this juncture, I will continue to call on the president to exercise his constitutional power and then issue knowledge through the Attorney General so that we can bring this thing to an end and open the door for reconciliation and peace building in the Southeast.
Common sense tells me there is a lot of complicity. I support what our attorneys have done. Fortunately, he didn't give a ruling, but I can tell you by the grace of God, Nnamdi will not stay in this prison in the next 2 or 3 months.
The trial judge, however, adjourned till May 20th for ruling on the application and for hearing after the court stood down the matter for 10 minutes for the defense lawyers to have a quick meeting with Kanu. Oluwatoyin Oyedola reporting for BTV News.